FERA become FEMA, it's a liberalized law. Regulation become management. But you go to operative chapter, foreign exchange, regulation and management. So it is FERMA. It's all some sensational, sexy titles by bureaucrats. No liberalization. It requires special resolution. Of course, this particular provision is a copy block of earlier thing. So let us move on to the next one, because we have got an important thing to study. Intercorporate loans investment, section 186, equivalent is 372A of Companies Act 1956, which still continues. See, there is bar on investment beyond 2 layers of investment. Now, beyond 2 layers, companies cannot have subsidiaries. In fact, already some of my corporate clients have called to restructure, to how to avoid merger, demerger beyond 2 layers to comply with this law, because they think beyond 2 layers there will be fraud. There is an assumption. If you are acquiring a company abroad under FEMA, this rule will not apply, because abroad when you acquire a company, there won't be fraud. Don't ask me how, but that is how you are told, so we have to continue to believe that. Unnecessary control for small companies. Disclosure norms. 56 Act, there are no disclosure. The company shall disclose its member. This is a good, it's an improvement. This amendment is welcome. The financial limit is same. Paid up capital, free reserves, which includes security premium, 60% of it, or free reserves and security premium, 100%, whichever is more. Interest rate, government security rate is now the amendment. Earlier it was RBI rate. Then giving guarantee without special resolution, not at all allowed under Companies Act 2013. The 56 Act permitted if board resolution is obtained and confirmed in the general meeting within 12 months. There are no exemptions. Exemptions are allowed in specific cases. Again, this section, equivalent to 372A 186 of 2013 Act, applies to all companies, although the ceiling limits are reasonable and special resolution is required instead of central government approval. To that extent, there is a very cosmetic minor liberalization. However, I still continue to maintain the provision is unnecessary for small companies that occupy Indian corporate population and provides for avoidable hurdle, and hence there is no liberalization at all. Now, this is the bare provision, because this is what I am supposed to talk. But friends, listen to me for 15 minutes. Relax. Let us get on to the facts. See what the corporate population, social reality of India. This is what it is interesting. The ground reality of Indian company classification. This is a statistics taken somewhere in October 2011. Read the statistics carefully. In India, the total number of company population is 11,63,130. 100% of companies. Companies with a paid up capital more than 5 crores is only 23,589, or 2% company. Can you believe it? And then there is another statistics, companies between 2 crores to 5 crores, similar number. But 5 crores is internationally, I took at that point of time 5 crores because it was $1 million. Now 5 crore, $1 million could be more than 6 crores. 2 crores is no size at all. 1/3 of a small company abroad. In UK, if any company is 1 million doing business with their own money, loan, etc., there is no regulatory mechanism except you incorporate, and there will be provisions when you commit fraud, abuse the law. That has to be retained. I have a feeling still 111, 237 investigation, 397, 398, 433 winding up provision, investigation, all must be retained for all companies. Even if it is at 1 lakh minimum paid up capital, because somebody can commit a fraud. You must have the whip. But the whole Companies Act is irrelevant. Say, for example, deduct the 2% from the statistics. In Tamil Nadu, there are 77,254 companies, of which companies above 5 crore paid up capital is hardly 1,893. 98 to 98% of the companies are unlisted, they are private companies, they are less than 2 crores capital, they are husband and wife family companies or friends companies, they do business with their own money, sometimes their own money taken away is the creditor also. Now they can't use, now you can ask me, I will give you some other statistics. What is the fundamental purpose of joint stock company? Somehow we started with something, we forgot, we have come to some more control system. The fundamental concept of joint stock company is to protect shareholders' interest, protect creditors' interest. Beyond that, there is nothing at all. Shareholders' interest is not applicable because their own company, their own money. Husband and wife shareholders, their own money, it applies. Why should government of India say, no, you are not supposed to be bothered about your money, I should be bothered about your money? Unnecessary. Creditors' interest. Most of these companies have no bank borrowing. Even if there is a bank borrowing, what happened? Banks first day itself lift the corporate bill, get the director's personal guarantee, property, then corporate assets, hypothecation, everything. So creditors' interest commercially is adequately protected, all your banks and institutions. They are not depending on the Department of Company Affairs to recover. The only section relevant for them is registration of charges. They will ensure that as part of the proceedings. Beyond that, company law doesn't, even persons can cheat taking all the securities. Now what I am saying is the company law doesn't anyway assure unlisted company creditors' interest beyond registration of charges. Then you may ask me, they can borrow money from private NBFC. When I was discussing in T, somebody was saying they can borrow money from private person. No, that is banned. By definition of private company, you can't borrow money. So that you need not protect because there is nothing to protect. Finally, you can say, forget about long-term creditors, forget about NBFC which are banned. They can have trade creditors and cheat because law cannot go on be assuming cheat and then providing for it. Trade creditors, if they are cheated, you have 433 winding up rights. Do you mean to say 433 or RD will come and recover the money and actually give you the check? No, he can only give an enabling provision. You have got rights under the act. So that is well taken. That is there already. What is happening? Companies with paid up capital below 2 crores constitute more than 96%. In fact, it is not 96, it is 98% of the companies. Listed companies are only 7,000 in India. Can you believe it? Not even 1%. Of the 7,000 listed companies, 1,550 listed companies are not at all active. They are banned, no trading by NSE or BSE. 5,800 listed companies are there active, which is 0.5% of the total Indian company population. All the provisions, whatever you have, then SEBI provision, stock exchange provision, a listing company, corporate governance, audit committee, this and that, more of it you have for all listed company. I have no quarrel. But you are ignoring 98% majority. You are creating 2%. You are assuming, sir, even in listed company, take for example Wipro, 25% must be held by public. SEBI issued a notice, you dilute your holding. Wipro was having, promoters were having 87%. You know what they did? They transferred 12% to a foundation for employees. So Wipro, there are 3 shareholders. Promoter 75%, foundation 12%, all other shareholders only 13%. Our float is not adequate. Our promoters even in listed company doesn't want outsiders. This is the reality. Actively traded company only 100. BSE numerator only 30. And direct investment in listed company by Indian investor does not exceed 3%. I will tell you some more statistics here to drive home what is that the department wants to address. It's a most fundamental issue. You see, I tell you to digress, one point to drive home the corporate population in India. FII investment, portfolio investment when it comes, 25 years before, when I went to US library, they said the moment foreign portfolio investment come, lot of shares will be traded, 10 times, 50 times of the company will got listed, start listing, more capital will come, more debt will come, more greater projects will come. That is the purpose of foreign portfolio investment. It has happened in some countries in the West. What is the Indian reality? Portfolio investment came. In 2006, they completely exempt capital gains. My chartered accountant friends will know. For secondary listed companies, they make a transaction-based tax. So they are tax-free. And lot of companies in abroad, US, their bank rate of interest return is only 1.75%. They went to Mauritius and started investing in Indian capital market. From 3,000 to 4,000, the index became 21,000. Two things are happening. I wrote an article, senseless, irrelevant Sensex in business line. Stock market goes up, it must be a barometer of economy. But during Diwali, the stock market went to 21,000. Not only stock market went, 3-4 other indices also went up. What are they? Fiscal deficit was highest, current account deficit was highest, inflation was highest, corruption was highest, Sensex was also highest. It's a paradox. And what has happened to listed company? How many times they have increased? In 1992, according to SEBI record, The number of listed company are only 5,800. In 2012, the number of listed company continued to be 5,800, adding new listing, providing delisting. Number of company newly listed are few, number of company who want to get out of stock market are more. This is the Indian reality. So the theory that FII will activate something has not worked in India. The theory that Indian women will spend has not worked in India. But economic policy making is in the control of economies. Economy is not in the control. We summarily reject. But they keep on borrowing policy from IMF, FS. They don't have contrarian thinking. They don't do the society reality. They keep the policy. Our individual company population works differently. Most of our companies are manned by family business. I tell you 2-3 situations, practical situations. You will all be agreeing with that by heart. Then I will ask you a question. How many of you agree with this? You raise your hands. First example. In one of my clients' case, they were clients to me from partnership firm in 90s, then in around end of 80s, then 90s, 92, they became a private limited company. In 2000, it's for 5 engineers. It's more a service company than anything to do with factory. That turnover was less than the capital. 6 lakhs was their capital, turnover was 5 lakhs in the year 1985. In 2000, when they sold the company as a limited company, they gave 25 crores to a multinational company. They sold. Last day, a chartered accountant and lawyer from US came. When the share certificates are to be seen, suddenly the promoter said, share certificates are lost. Then I was shocked and embarrassed. Later on we found share certificates were not lost, simply it was not issued. Then we went through the book, all the bonus issue, then work out everything, created the share certificate, issued it fresh, transferred it. That's a different matter. What I am saying is, despite share certificate not being not issued, there was no dispute among the promoters because they were friends. They never bother about board meeting or secretary. Only when acquisition comes, they do everything. And they were able to sell from 5 lakhs of turnover to 25 crores. They made it. Market has accepted it. Why Department of Company Affairs should have problem? I don't understand. I will tell you another example which all of you will relate. The moment you go for a bank borrowing, open a bank account, you are supposed to give a resolution copy, right? Let us see from the human side, we will develop it. Immediately what you do? You are supposed to go to the minutes book, the folio, take the resolution, copy it and give. That is a normal procedure. But what is a practice? You give whatever resolution they want, put it in a file. In the end year, you consult the minutes. Is it true or not? I am not blaming this. That is the Indian reality of small company. We are doing it only for Department of Company Affairs. Promoters are fine, bankers are fine, you are fine, everybody is fine except DCA. Third example, when I was presenting this forum in a company secretary institute, when the company bill came in the West, I asked them one question. How many, most company secretaries have private limited, unlisted, public company clients? One of my friend, I asked him, how many clients you have? He said, I have 190 clients. Then I asked him one question. 190 private company clients, how many of your private company, under 1956 Act, the total number of members for a private company is 50. In the 2013 Act, it is increased to 200. I asked him, even in the 56 Act, how many of your private company have exhausted 50 members? He said, only one. I was interested in knowing about the one. Then he said, it's a Marwadi family, 42 members are there. When I went through that, the 42 members are only kith and kin for dividend distribution, tax source, only 3 members were doing. And no board meeting happens. Whatever the elder brother says, everybody follows. Then, when I wrote the second article, I went to another, if this were the situation, what is happening in the West? What is happening in the East? In the West, is relationship is contractual. I am talking about the most fundamental human behavior of sociology, based on which law is built, how it is flawed. For an Indian society, we have English Companies Act. Only thing, there is a change. Earlier it was English Companies Act 1956, now it is English Companies Act 2013. We still yet to have the Indian Companies Act. In West, what happened? Even in a small company, there is no relationship. Promoter forms the company, private equity funds comes and invest, venture capital fund, they conceives the investment contractually, conducts the investment contractually, concludes the investment contractually. That is why governance, arm's length, everything becomes important. Here what happened? Corporate members need not have to do arm's length transaction because they have become related party. Parties who are otherwise biologically thickly related have come to corporate vehicle to doing business. They are radically different. This fundamental issue is not being seen. I have a client who does a turnover of 220 crore. From 1977 till date, 3 brothers were doing successfully. Their total borrowing from the bank is only 5 crores. As against that, they place 17 crores fixed deposit to bank. Net, they give 12 crore loan to bank. They don't take any loan. They have number of private companies. The group turnover is more than close to 300 crore. I have number of such clients. I can't narrate such thing. Most of them are service company, IT company. All these laws have absolutely of no relevance whatsoever. Where from we have copied the law? We have copied the law from UK. I went to UK website. Companies up to 1 million pound, they are free. They need not audit. Who are the auditors supposed to report? Only to shareholders. Husband and wife, they form the company. Why are you reporting to them about their finance? They know better than you. What is the fundamental purpose? I don't understand. Department knows about it, but there is a big